Order is now open. You may proceed. Mammone versus the President of College and Health College.
Thank you.
Okay, Ms. Ehrenberg.
Good morning, Your Honors. My name is Betsy Ehrenberg. With me is Rebecca Ponticas, and we represent the plaintiff appellant, Michael Mammone. There are three issues before the court on this appeal of the grant of summary judgment to Harvard on Mr. Mammone's claims of handicap discrimination, and I'd like to spend most of my time on the first of those issues.
And the big question, which I know you're going to talk about, is how do you distinguish this kind of situation from Garrity?
That's correct, Your Honor.
Before you get to that, could you just help me out on a fact question, please? What was the evidence most favorable to you as to how long the plaintiff would need, what his doctor said, how long he would need to to recover from his disability, leave, how long he would need disability leave for, and when was Harvard notified of that date?
Mr. Mammone's doctor submitted regular reports to the Harvard Disability Office, and the report of March of 2003 indicated that Mr. Mammone was calm and reflective and seemed to be doing well, was handling efforts to obtain employment and efforts to regain employment well. And once the litigation began, the doctor submitted a letter that Mr. Mammone would have been able to return to work.
Oh, but that was after the litigation began. So Harvard didn't have any date. Harvard was not told before the litigation began of a date when they could expect him to return.
Well, with all due respect, I think Harvard never engaged in any such inquiry and deflected any attempts either by Mr. Mammone through his union or later through an attorney to prompt a discussion of when or whether Mr. Mammone would be able to return to work. And so, in fact, it was the failure of the interactive process that I think resulted in the fact that the doctor, while issuing a report from which one could infer that he was ready to return to work, never made the statement that he was returned to work because Harvard never engaged in a dialogue that would have made that statement make sense.
Right, but could I ask you, if an employer has made a decision, and at the time the decision is made, on the information that's then available, the decision is lawful and proper, is there anything that requires them to turn the clock back and revisit that decision if later they are provided with information? I take it none of this was in front of Harvard at the time of the original decision to terminate Mr. Mammone.
Well, with all due respect, here's what was in front of Harvard, and let me talk about it in light of what the purpose of the anti-discrimination law is with respect to handicap. First of all, that law is different from most of our other anti-discrimination laws in that it imposes an affirmative obligation to reasonably accommodate a qualified individual if that accommodation is reasonable and may enable that individual to perform the essential functions of the job. And so with that affirmative obligation and with a set of facts where this individual had worked for Harvard very successfully in this same position for 7 years during a time that he had been diagnosed with the illness, and that when the behaviors that arose were recognized by coworkers in his environment as being uncharacteristic of his past performance, uncharacteristic of him personally as they knew him, and struck them as evidence of a psychological problem. He was described as his emotions being out of control, as suffering a psychological problem, as needing medical intervention. And the law and the guidelines construing the law is clear that where an employer knows or has reason to know that there is a handicap that may be accounting for the conduct that's being observed.
And was that the case here? Did the employer know there was a handicap?
I think the evidence viewed in the light most favorable to the plaintiff, the answer to that is clearly yes, and it's clearly yes for a couple of reasons. One, there's deposition testimony from the plaintiff that he had discussion with supervisors in the past in which he alluded to his illness. But even more powerfully than that, when this conduct arose, the email from the assistant curator, Ms. McLaughlin, or Mr. McLaughlin, I'm actually not sure which, the first name was Castle, to the supervisor read, I have always felt that Mr. Mammone was both professional and personable. He seems to be experiencing psychological problems. He seemed to grow more irrational. He returned after the holiday with tales of union goons. My concerns are, she says, or he says, are for Michael's health and sanity. Now, this was a layperson who knew Michael and who made the observation that something psychological was wrong here. This was uncharacteristic behavior and should not be taken as behavior that was the product of reflection or judgment.
But how does Harvard know anything about whether this is even curable, treatable? They know nothing. You're asking, it seems to me, to without any information from a doctor, from a psychiatrist, from anybody, to come up with an accommodation in the dark. They know he has a problem, but they haven't a clue.
No, in fact, what we contend Harvard was obliged to do was to obtain information from which it could have made a reasoned decision.
Who could they get that from?
Absolutely. They could have gotten it from talking with him, obtaining his permission to speak with his doctor. His doctor was sending information into the disability office. What the law requires of an employer is not that the employer make the decision without any information, but that the employer engage in a process, inform itself, and educate itself as to whether this individual could perform his job with a reasonable accommodation.
Decision, I take it they told Mr. Mammone to stay away from the premises.
Here's the evidence.
I'm a little troubled. If they say that, okay, we're going to sort of at least keep everything calm by keeping away from the premises while we try to figure out what we're going to do. And the very next day, he's back on the premises. He presents a kind of an emergency problem that this duty to accommodate and to make these inquiries has to be viewed in the context of a person who's engaging in this bizarre behavior who won't even stay away from the premises.
Well, but let me talk a little bit about the evidence in the light most favorable to the plaintiff on that particular point, and then also talk a bit about the larger view that handicap discrimination law requires that we take, else it would have no meaning for individuals with mental illness. On the first point, Harvard, the evidence in the light most favorable to Mr. Mammone was that perhaps a security guard, when they were carrying him out of the Peabody, said, "Don't come back here," which Mr. Mammone may have taken to mean the Peabody. The letter that tells him to stay away from the larger premises he did not receive before he returned to the Museum of Natural History, and he, in fact, did not even receive it before he learned that he was being terminated provisionally. So that one cannot look at this evidence and say a message was delivered to him which he received and which he comprehended, because he was in the throes of mental illness, which is defined by, in his case, paranoia, irrationality, loss of judgment. That is the nature of the handicap itself. And subsequent events showed that once he returned to the Museum of Natural History and then again was confronted by Ms. Pipponidis and Ms. Reynolds and told to leave again, he left. He left peaceably. He made a truly unfortunate statement, but he took no action against them. He walked by them. One of them followed him out the door. And thereafter, he did not return to the premises.
Followed out the door to get the police. Am I misreading the record here?
No, I think she probably did follow him out the door to get the police. But the record evidence is that he walked out the door, began walking away from the premises. She walked out behind him, hailed a police car, but he, by that time, was on a path away from the premises. And thereafter, he did not return.
Can I interrupt you?
He went to the University Health Services. He
Can I interrupt you for a minute?
Sure.
Was there any evidence that the University Health Services, prior to the time you're talking about now, had information that he was bipolar?
I don't.
You said doctors were sending, his doctors or someone from the doctor's office were sending information in somewhere? This
is information that began to be sent after
the trouble.
The events that we've been talking about.
Now my other question is this.
But he saw that psychiatrist within a day or two of these events.
All right. My other question is more global, and I'm sure the defense is going to address this too. The courts, federal courts, have struggled with this issue. It's all in your briefs, and they're split. I could see a distinction between alcoholism and drug use, which is bad. You know, they're bad things to have, but they are technically controllable. And mental disorder, where, as you claim here, the mental disorder, in effect, creates the conduct which, under Garrity, is grounds for discharge. My problem is that if we fit this into Garrity, and I'm asking you how you're going to distinguish Garrity, we effectively have taken all people who have mental disorders out of the protection of 151B, because the minute they throw an episode, which is bad, they can be terminated. So how do you get them within 151B if you ever do?
Well, I think, I mean, with all due respect, I think that that's why Garrity is wrongly decided if it stands for the proposition, the per se rule, that a disabled individual may be lawfully terminated for conduct for which a non-disabled individual would be terminated.
But isn't there, in fact, language in Garrity that permits some openings to carve out the kind of case we're talking about here today?
Right, but on that point, if I may, I think we all need to be reminded that this is a summary judgment case. The problems raised by mental illness, in terms of applying a rule that balances an employer's right to create a safe and productive workplace with the handicapped individual's right and society's determination that it is in our best interest to have handicapped individuals work where they can with reasonable accommodation when necessary. That balance is elaborated by a procedure that says if there is a direct threat posed by an employee in the workplace, the employer does not have to tolerate such conduct, but the employer has to inform itself and base that assessment on reasonable medical information. It also says that, I also want to stress that there's a place here for a misconduct exception, if you will, which, I mean, this is a continuum of behavior. We're talking about behavior that could range from, on the one hand, behavior that is at odds with workplace norms, but nonviolent, non-assaultive, non-criminal, on the one hand, and behavior that is a paranoid schizophrenic coming into a workplace and pointing a gun at a supervisor and threatening to kill the supervisor. Now, if that conduct is the product of mental illness, I don't want to be heard to be asserting that is a situation where a termination may not be warranted.
Is that your line, gun in the office, or is there a line somewhere else? How about if he had been stealing money, he was in charge of getting the receipts, assuming he needed a treasury to fight the conspiracy, he had been stealing the receipts, and the employer found out he'd stolen a large number of receipts. Would that be the basis? We
entrust juries to make very difficult decisions all the time, and this is simply not an issue where a bright line can be delineated quite so clearly. It reminds me
Why
of
not?
Justice Stewart's saying, I don't, obscenity may be difficult to define, but I'll know it when I see
still,
it.
I mean, if the behavior is disruptive, reasonably interpreted as threatening, which I think it can reasonably be interpreted as here, it does seem to me that poses this kind of emergency situation from the employer's point of view. I mean, one thing, if the mental illness was caused, say, attention deficit disorder, and the person isn't paying enough attention to details, you've got time to investigate that, to do all the things that you're supposed to do. But when you have this kind of immediate quasi-crisis, it's a little hard to say, well, let's send a letter to his doctor and get waivers of confidentiality and investigate if he's...
But we're not saying that the employer would not be justified.
You can answer that, and then your time is up.
We're not saying that the employer would not be justified in taking steps to remove such an employee from the workplace while that investigation takes place. And let me just leave you with perhaps an analogy.
I know your time is up. That could be done with the person with the gun, too. Oh, just keep him away while we find out whether we can't do something to see to it he doesn't come back with a gun.
But what you're saying is, in a case like this, where there is evidence, in the light most favorable to you, that the Harvard people knew this was psychological, they're under the handicap law, they're bound to go a little bit further and not just say, well, you're out of here and you're fired.
And the MCAD guidelines carve out drug and alcohol use and say that misconduct may otherwise have to be accommodated. So this, and the better reasoned cases from federal circuits typically deal with drug and alcohol conduct, or if they don't, typically deal with far more egregious, violent. I'm sitting down now.
Thank you.
Thank you very much. May it please the Court, my name is Jack Oakley, and I represent the President and Fellows of Harvard College in this matter. Justice Cordy, I think you asked earlier, where would you draw the line in the cases of misconduct related to a psychological handicap? I believe Garrity has already done that, and it hasn't just done it for cases involving psychiatric-related misconduct. It has done it for cases involving any type of egregious misconduct which is inimical to the business interests of the employer.
Does that mean any kind of misconduct that would otherwise result in termination of employment?
I believe what Garrity sets forth, sir, is misconduct that would justify the termination of a non-handicapped employee. It requires equal treatment.
It has words like substantially interferes with the employer's...
Significant.
That's
significantly inimical
inimicable
to the interests of his employer. Egregious misconduct is also used. And if you compare what happened...
What do you do with the problem that the employee here has no control over this? This is not alcohol. This is not drugs. He didn't come to work drunk. He didn't come stoned. He doesn't know what's happening to him. He's gone bipolar. And these people are aware of this.
I'm not sure that the record certainly doesn't indicate that the Harvard University was aware that he was bipolar or aware of any diagnosis. They had
but they were aware that
he was
most
engaging in
favorable
misconduct.
to him that there were perhaps psychological problems here.
A layperson sent an email, not to stray from course, but a layperson sends an email, and the supervisor approaches Mr. Mammone to discuss what was at that time misconduct which he had not been terminated for and no disciplinary action had been taken against him. In response to that overture, which I guess could be interpreted as being initiating a dialogue with Mr. Mammone about his misconduct escalates. He's not terminated at that time. He's asked to leave the premises.
Was this when he was asked to attend a meeting or something?
Exactly.
And he says, you're evil, get away from me.
That's in response to the initial overture by the supervisor to have a discussion with him, which he rejects. He's then asked to leave, and he sent a letter inviting another meeting, or actually directing another meeting with his collective bargaining representative for a later date, and telling him not to come back to the premises.
But he doesn't get that letter, right?
Correct, Your Honor. I believe that's further indication. He was not, in the face of this misconduct, his initial misconduct, which did not give rise to a termination or any disciplinary action, it was not ignored. In fact, overtures were made for this individual, which I submit under Garrity, they weren't even required to do. At least they weren't required to do as of the time he committed the egregious misconduct.
You alluded before to lay testimony, and you argue in your brief that the plaintiff didn't have any expert evidence that his misconduct was related to his bipolar disorder, just his own lay witnesses and emails from coworkers, but the plaintiff says you did not raise that argument below. Is that correct?
Oh, I believe we argued that he was not an otherwise handicapped employee, and his
You didn't
defense.
argue a lack of expert evidence. I mean, did you? I'm asking you.
I don't believe we mentioned, we specifically stated he did not proffer expert testimony, but I would submit that to the extent in response to our summary judgment motion, that the plaintiff argues that his misconduct should be not treated under the Garrity decision because his misconduct was related to a psychiatric disability or was compelled by a psychiatric disability. To the extent that he raises that issue as a defense to the Garrity decision being applied to him, it is Mr. Mammone's burden to present facts that would justify the application of that modification, deviation from the Garrity decision.
Hasn't he been diagnosed as bipolar?
I believe he's been diagnosed as bipolar, but there's no opinion that his behavior on September 4th and September 5th of 2002 was the result of his medical conditions and/or that it was otherwise involuntary.
Well, let me ask you this. Do we have different rules for people who suffer from alcohol or drug issues and people who are mentally ill engaging in the same behavior?
I believe Chapter 151B, if you look at the text of Chapter 151B, it does not provide for any differing treatment. If you look at the Garrity decision does not indicate that it is limited to misconduct that is a result of alcoholism. In fact, if you looked at the text, it's actually much, much broader than that.
So where do the MCAD guidelines come from that do distinguish misconduct as a result of one versus another?
First of all, they were promulgated after Garrity, so I don't believe they accurately reflect the law as set forth in Garrity, at least as the guidelines are being described in the amicus brief by the MCAD. What they appear to be doing is adopting the minority holding, the minority treatment of this issue under the ADA and Rehabilitation Act in the federal courts.
And is the language of that act different? Does it specifically, the statutory language, treat drug and alcohol abuse differently?
It does, Your Honor. There are express provisions in the Rehabilitation Act and in the Americans with Disabilities Act, which at least the few federal courts that have adopted the treatment proposed by the MCAD, which actually aren't the courts that the Garrity court cited.
Right.
The provisions in the ADA is 42 U.S. Code 12114, and provide support for the argument that an alcoholic misconduct committed by an alcoholic is not protected. And similarly, in the Rehabilitation Act, 29 U.S. Code 705, it also specifically makes reference to people with an alcoholic-related disability, and that they can be held to the same work standards as other disabled or non-disabled employees.
So the MCAD guidelines, however, were in effect when these episodes occurred or were not?
The MCAD guidelines were implemented in 1998, so they were in effect at the time of
Mr.
Mammone's misconduct, but they're not in effect at the time of the Garrity decision.
No, I understand that. But the question I asked co-counsel, and how do you respond to it, if in effect you have a mentally ill person who does this kind of activity, and putting aside there's no gun situation here, or the other things we were talking about, to hold the way you hold would in effect take them out of Chapter 151B in every case, wouldn't it?
Only in cases where they engaged in egregious misconduct, which would have warranted determination of a non-disabled person. So actually, they would be treated. They're being treated exactly the same as a non-handicapped person. They're not being discriminated against. They're being treated the same. And to the extent that the proposition has been made that either alcoholism or drug addiction is volitional behavior, and for that reason it should be given a less protected status under Chapter 151B. The Garrity decision states that describes the misconduct by the plaintiff in that case as being the result of an irresistible compulsion, and her alcoholism was described as a psychological addiction. So I think even if you look at the Garrity decision, I think even that provides support for the proposition that psychological misconduct is not protected, and misconduct that is the result of involuntary behavior caused by
Well, I do agree with you that the Garrity case appears to cover this to your favor, and that if we are going to go the other way, or any of us are going to go the other way, it would have to come to some meaningful distinction between what occurred here and what happened in Garrity. but
Can I ask this question? Because I understand there are sort of three things, it seems to me, involved in the disability statute. One is ensuring that there's not disparate treatment between people who have got a handicap and people who don't. And on that theory, I think Garrity clearly rests fairly firmly. A non-handicapped person will be fired for this conduct. Why shouldn't a handicapped person be fired for the same egregious conduct, assuming it's egregious? But there's also this affirmative obligation to reasonably accommodate handicaps. And what position did you take, if you took a position, in your summary judgment motion on the reasonable accommodation issue?
Once Mr. Mammone engaged in the egregious misconduct, which would have warranted, by his own admission, would have warranted the termination of a non-handicapped person, he was no longer protected under the statute. So he no longer has a right to engage in a reasonable. He no longer has a right to reasonable accommodation.
Okay, so you took that. You didn't take the position that even if he were entitled to some reasonable accommodation, he never requested one. Whatever was put forward was hardly reasonable because it was not definite. There was no time frame. You didn't argue that.
Well, we actually did.
You did. Okay.
We had multiple lines of defense
All
on
right.
this. And the first one was he didn't have a right to reasonable accommodation. And even if he did have a right to reasonable accommodation, the combination of Ms. Pippinitis' original overture to him before his egregious misconduct, trying to engage him in a discussion of his behavior, the subsequent letter inviting a second meeting, that constituted a dialogue. And subsequently, the only request he ever made, at a time, I might add, that he was represented by counsel, which I submit would have relieved Harvard University of any obligation to assume the entire burden of initiating and carrying the interactive dialogue, which, again, I submit that there was no obligation to do so. But assuming there was, Harvard University should have been obliged to initiate it or to moderate the entirety of the dialogue.
Well, that letter basically said we're suing you. We're filing a complaint with the MCAD. But it also said, you're not being reasonable.
And he needs some time off. This
Right.
is 3 months after the incident. No return to work date is provided. No estimate as to when he'd be able to return to work was provided. In fact, it never was provided. And in his deposition in this case, he testified that as of then, he had never been told that he was fit to return to work. It was only after the summary judgment motion in this case was served that the letter from the doctor was produced, which sort of had a hindsight retroactive quality.
Now, let me get to Justice Graney's question, because there's a third issue in discrimination cases, and that is whether, even if the rules seem to apply to everyone, there's a disparate impact in how they actually apply to handicapped people. And here you're talking about someone who, yes, the rules are you can't act up at work, but if in fact the mental illness is what's creating the acting up, the very disability is creating the very acting up, that seemingly neutral rule will have a disparate impact on people who have a particular handicap. Isn't that a problem?
But I don't believe there's a disparate impact claim in this case. And if there was, there's not a record that would suggest that people with psychiatric disorders engage in the egregious misconduct discussed in Garrity to a greater or lesser degree than would just your run-of-the-mill bad troublemaking employee. And in the absence of a record such as that, I don't think that the decision by the Superior Court should be.
Now, I guess what I'm really referring to is the fact that a seemingly neutral rule will in fact have significant consequences for folks suffering from a particular kind of mental handicap and not others, so that it does have a very specific impact on one class of protected persons.
I don't think there's that claim has been raised. I don't believe that record has been created. And then I think when you have to look as a practical matter, the rules set forth in Garrity, it mandates equal treatment, not just equal treatment between handicapped and non-handicapped employees. It mandates equal treatment among handicapped employees themselves. I guess the rule proposed, or the outcome proposed by the plaintiff and the amicus filers would actually provide a preferential treatment, not for all handicapped persons, but for one subset of handicapped persons.
Well, where's the judge seems to conclude that this is egregious conduct such that it warrants the termination. Isn't that a jury issue, or shouldn't it be a jury issue?
Well, in Garrity, it was a summary judgment issue. And I believe if you compared the facts in Garrity to the facts in this case, I believe that the judge was correct, that no reasonable fact finder can conclude that the conduct engaged in by Mr. Mammone was not egregious. And I think actually what is certainly outcome determinative was Mr. Mammone's statement at his deposition, his agreeing with my statement at the deposition, that if this behavior was committed by a non-handicapped person, that would have warranted termination. So I think, especially in light of Gary and that being a summary judgment decision, and the undisputed facts in this case, I certainly believe there was no disputed issue of material fact that this conduct was egregious, that it would have warranted termination of a non-handicapped person, and that and there certainly is no evidence of pretext.
When he made the statement to the Pippadonis and Reynolds, you know, you effing bitches, whack bitches, you are going down, do you take that as a threat along the lines almost of the gun situation?
I believe that is objectively threatening conduct. And the record also contains, the summary judgment record also contained a letter from Ms. Pippinitis to Mr. Mammone. It was actually the letter which indicated to him that he was being terminated. And in that, this is how Ms. Pippinitis describes the conduct. Although you were informed not to return, you did so anyway. And at that time, you confronted, threatened, and verbally abused me and the HR administrator, Mary Reynolds. So certainly, according to Ms. Pippinitis, you know, she was being threatened. I think objectively speaking, she was being threatened.
And that was written contemporaneously, the very day it happened.
The next day.
The next day.
So she felt you could, well, all right,
I
never
believe there are
mind.
facts in this record that indicate that she felt she was threatened. And also, I think I would like to add a couple facts to the way in which this incident was described.
Well, you better add them quick.
And before you add, let me ask you, with respect to the interactive process, if a plaintiff is incapacitated by his mental illness such that he's not able to participate in an interactive process, what kind of adaptation should be made to how that process should be engaged?
I mean, first of all, I think when he engages in the egregious misconduct which would warrant the termination of a non-handicapped person, I believe there is no, under Gary, in the majority of the way this
If we don't agree with that.
But if it doesn't, perhaps the first letter that Harvard University sent to the plaintiff indicating we're going to have a meeting, bring your collective bargaining representative.
And he has a lawyer, but he's paranoid, and this whole thing doesn't mean anything to him.
Well, Your Honor, once I think he has a lawyer, I think it's unfair then to shift the burden to the employer to carry the burden of either initiating or even formulating a reasonable accommodation where you have an employee that's represented by counsel, particularly counsel of the quality of Mr. Mammone's.
What did you want to add very briefly, or do you want to send it in later?
With respect to the incident where Mr. Mammone used the slur toward Ms. Pippinitis and Ms. Reynolds, the suggestion that he made no motion or took no aggressive physical movement toward those individuals is not the case. The undisputed facts, I'm not talking about a deposition testimony, I'm talking about the Superior Court Rule 9A B5 statement, and the plaintiff's response indicates that he was in a phone booth at the Museum of Natural History when he was approached by Ms. Pippinitis. And he acknowledges that when he saw them, he came out of the phone booth and he pointed at them and he made that statement. So the suggestion that he sort of made the statement as he was turning his back and walking out the door is not an accurate representation of what's undisputed in this.
All of this is in the record, and we'll take a look at it.
It is, Your Honor.
Thanks.
Thank you.
All right.